This is Good Morning San Diego.
On Friday, a block on President Trump's executive orders restraining DEI programs was lifted. Join me now to talk about that and why judges are trying to block the president's orders is criminal defense attorney Vikas Bajaj. Vic, welcome back to KUSI.
Thank you.
All right, well, we're seeing the strategy. If you can't beat them at the ballot box, then you try to slow them down using judicial restraint on executive decisions. Isn't that what we're seeing right now?
In a nutshell, absolutely. You hit the nail on the head, but it's not the whole judicial system. These are the lower courts. These are district courts. So in the federal system, we have district courts, which are like our state trial superior courts in California. Then we have circuit courts, which are the appellate division of the federal system. And then we have the great United States Supreme Court. And so what we're seeing now is some judges at the lower level, what we call the trial level, at the district court level, they're saying, you know what, this is too much. We're not going to allow President Trump's executive orders to pass muster. However, this is a significant issue, as even we've seen in the Fourth Circuit Court of Appeals, which just reversed an injunction by a lower district court judge, which said no DEI policy abandonment, which was asked for by President Trump as an administration. Now what's happened is the Fourth Circuit has said President Trump is the president of the United States. He's allowed to do it. And most importantly for that court's decision, Paul, the court said the district courts cannot be so broad. These lower local district courts can't make national policy or abolish national orders. So there must be specific standing.
So if it can be lifted for the DEI programs, then can it also be lifted for what is going on at the DOJ level, as far as everyone's pushing back about the president is using a sledgehammer instead of a scalpel, and we have to slow that down, and these decisions have to be reviewed. Can that same reversal at the DEI level be also held at the DOJ level?
Well, absolutely. It's very interesting when you talk about the scalpel and the sledgehammer. We've also heard the scalpel and the butcher knife, right. And there's different cliches out there. But if you actually think about it and you look in the mirror, you figure the scalpel is what's required in the district court level. And what we've had here in the Fourth Circuit Court of Appeals decision regarding DEI that we just talked about is the court saying, hey, the lower courts can't use a butcher knife. They can't use these big issues. We need a scalpel. We need the specificity on an individual plaintiff to have standing. So this is the rub. Now, can these lower courts do that? Now we've found at least the Fourth Circuit saying no. Most courts are going to follow that lead and say, no, it's not specific enough.
But isn't the penalty the process? By slowing it down, the hope is that eventually by the time all this gets in front of the Supreme Court, there will be a new occupant in the White House?
That's right, but this is expected. I mean, if you look at it at a lower level, you say, hey, boy, I can't believe they raised opposition. I can't believe these local left-leaning judges are saying you can't do what the people elected you to do, President Trump. But it's all expected. And so that's why we have circuit courts, and that's why we have a Supreme Court of the United States. Don't forget, Article 2 gives specific power to the President of the United States, and this is what the originalist court will look towards at the Supreme Court level.
And for those who are wondering how the Supreme Court is going to come down on that, because I know there's been some disappointment on the conservative side with a couple of the Supreme Court justices. In essence, haven't they already ruled on this very issue as we were going through with Jack Smith and everything?
Absolutely. They've ruled on this issue, but there's always a different color painted over it. So now we have, you know, people will say a 6-3 court, some will say a 5-4 court, depending upon where justices like Amy Coney Barrett stand on these particular issues. But we have an originalist court. There have been very few decisions other than Second Amendment decisions and things of that nature that have looked at what the text is of the Constitution, not a living, breathing Constitution that can ebb and flow with a political soup du jour, let's say, but an originalist concentration. An originalist interpretation of the Constitution has one consequence. The President of the United States has this authority.
And last question to you, Vic. At what point does the Supreme Court say, enough already, we're stepping in, or we're going to clear all this up?
I think it's going to happen sooner rather than later. If you have federal district judges around the country coming forward with differing decisions, the Supreme Court's obligation is to have consistent rule of law. We're going to see their intervention, I believe, a lot sooner than most people predict.
On that, we'll call it a conversation. You have a safe St. Patrick's Day, and we'll see you down the road when that decision comes down.
Yes, you as well. Thank you.